Well, hello there, and welcome to the Employment Law Show again. Thank you so much for joining us for the next 30 minutes. Hang in there. You're going to learn lots, as you always do, about employment rights and workplace rights as well. They're pretty robust in your favor, but they're kind of like the benefits at work. Unless you don't take advantage of them, you don't know about them. You might have $5,000 in massage, and I never used it. My wife tells me every time, but there you go. Lior Samfiru, of course, John Scholes, ready to handle you for the next half hour. We got our weekly features coming up. We're going to get to our phone calls from our radio shows, our employment rights, rapid fire near the end of the show, and lots of stuff in between. Want to reach out to Lior anytime? Feel free to do so. 1-855-821-5900, help@employmentlawyer.ca, and the website pocketemploymentlawyer.ca. Crafted by Lior some time ago. It's a beauty. It's free. It's anonymous, and you'll have access to the severance calculator as well. Millions of Canadians have used it, so take that for a spin, like we like to say. A little later on in the show, fact or fiction, termination or cause. We'll get to those, Lior. But first, week that was. What are you thinking about?
Hey, John, employment law is
good.
What I'm thinking,
Oh,
and a
start.
shocking twist. Happy to be here, happy to be talking employment law, happy to be demystifying this topic. Every single day I get calls, I get emails from people that assume certain things about their rights, assume certain things about what their boss can and cannot do. And in the vast majority of cases, those things are not true. They're not accurate. Well, on the show, we'll tell you what is in fact true, what your rights are if you're facing a workplace dilemma, if your boss has mistreated you, if your job is in jeopardy, what to do, what to say, what not to say, and of course, what does the law say for you? So important that we all understand those rights. So important that we know what to do, because it's not always going to be sunshine and rainbows in the workplace. Sometimes we're going to have difficult times, and on the show you'll learn what to do in those times. And of course, beyond the 30 minutes of the show, if you want to reach me in the office, we're going to have a private chat. John gave you the contact information. We'll keep giving it throughout the show so that you know what to do. Phone and email is there for you across Canada. Now that we know that, let's start with the situation that came across my desk over the past few days. I spoke with a gentleman who some time ago had to go on a short-term disability leave. Everything was fine. His employer gave him the time. He applied for short-term disability benefits through his insurance company. They paid him that. But unfortunately, after a few months, he was still unable to work, and his doctor agreed, and he applied for long-term disability. Except at that point, his insurer said, no, we don't think so. We think you should be able to go back to work, so we're going to deny your long-term disability claim. So he's, in the meantime, trying to convince with them, trying to appeal that decision, but now gets a letter from his employer saying, hey, we understand that you don't qualify for long-term disability. That means you should be coming back to work, so we expect you back to work on Monday. So he's extremely upset. Frankly, he's freaking out. And he calls me then saying, what do I do? I'm trying to get benefits from my insurance company so that I can live and pay the bills. And my employer is now saying that I better come into work Monday. And all this time I actually can't work. So what do I do? So, of course, let's start with the insurance company. The fact that your insurance company denies you those benefits doesn't mean that they should be. In the majority of cases, if your doctor says you should be getting disability benefits, that's all that matters. And the insurance company should not do anything other than pay those benefits. Now, they may want you to file an internal appeal. It's a waste of time. What we need to do is push back. We have a team at the office dealing with that exclusively to get the insurance company to do the right thing. But even if we put that aside for a second, the fact that you've been denied disability benefits does not mean that your employer can insist on you coming back to work. In order to be off work, all you need is a doctor's note. So as long as you have a doctor's note saying that you cannot work, that's it. Doesn't matter what the insurance company is doing, doesn't matter what the insurance company believes or doesn't believe. If you have a doctor's note, the company can't do anything to you. You have to be allowed to be off work, whether it's for another week, another month, another year. You get the idea. And if your employer does anything to you other than let you take that time off, you call me. I'll get them off your back. If needed, I'll get you compensation. But you cannot be told to go back to work unless your doctor agrees with it.
It's interesting. I'm thinking that whole phone call, and as you're talking about this and dealing with the disability insured, this whole question we went repackage and repurpose for our other show, the Disability Law Show, where they're going to touch on the employment aspect of it. But you're right, that internal process of the appeal is just you're appealing to the same people who cut you off. They're just dangling the carrot. It's not going to get you anywhere.
Well, honestly, they're doing that so that you feel like you've tried something, and then when it doesn't work, you say, well, I tried, I guess there's nothing else that I can do.
Right.
Nonsense. No, that appeal is a waste of time. It's there to frustrate you, frankly. What we need to do is to utilize the legal system to force the insurance company to do what they're required to do. We do this every day. It's not complicated. It's not even long, okay? So do that, and don't waste your time with a process that's not going to give you a result.
A lot of confusion people have between taking sick days, the amount of sick days they have, and being off for sickness. Those don't jive. Most people think they do. That's why employers sometimes call them back to work, right?
Yeah, and employers get this wrong. I know employees get this wrong. So let's say you have 5 sick days from your employer. What that means is your employer is going to pay you for 5 days if you're sick, even though you're not working. That doesn't mean that you're only allowed to be off or sick for 5 days. What happens if you're sick for 6 days? Well, that means on that 6th day, the company may not pay you, but you can still be off work. So you can be off work as long as you need to. There's no time limit, so long as you have that doctor's note. Now, you can apply it for EI sickness benefits. You can also apply to disability benefits if you have that through work. But the fact that you have a certain number of limited sick days that the company provides has nothing at all, nothing to do with how long you can be off work.
And again, something we've mentioned on previous shows is your employer can't say, okay, you're off. What's wrong with you? What's going on? Why are you sick?
John, every single week, I'm not even exaggerating, I get 2 or 3 emails from someone where they're faced with that situation where their employer wants to know, tell me what your condition is, or better yet, have your doctor fill out a form where they tell me everything about your personal condition. No. Overreaching can't do that. They're allowed to know if you're working or able to work, if you're not able to work. They're allowed to know if there's accommodation that could allow you to work. Beyond that, anything private, anything personal is offside. You should not give that information.
And you can always refer to employmentlawyer.ca, the website, anytime for all this information and so much more, including where to find our weekly radio show across the country in Toronto and BC and so on and so forth. You can actually participate in those radio shows on a weekly basis. Just call the number when we tell you where and when to call, and maybe your phone call will appear on this show. We'll talk about it. Phone call number 1, Lior, for this week is coming up right now.
Our friend has been working for about 14 years for a private school. He's been working in janitorial services, so they are now trying to get rid of him. They've said all kinds of things about him, and there's no proof to anything. And now they have, via email, a letter, and they say he has till Tuesday to sign it, and they're offering him $7,000.
Wow. Yeah, we were both shaking our head here while this was playing. So let's start with the idea, John, that an employer that wants to establish that you've misbehaved, they have that onus. They have the burden. So you and the employee don't have to prove that you didn't do something wrong. The company has to prove that you did. And to be able to use that to avoid paying you severance, it's a very high threshold. Not only do they have to prove that you did it, they have to show that it was bad enough that you just can't be employed anymore. So if this call that we played is correct and these are false allegations, the employer is never going to be able to prove it because it's false. It never happened. So this person is going to be owed his full severance. That's going to be, after 14 years, a lot more than $7,000. So let's use our severance calculator tool. Of course, you can find it at pocketemploymentlawyer.ca. It's free and anonymous. You should always use it if you're losing your job or are worried about losing your job. And let's see, in this particular case, what does that give us? So a janitor working in a private school for 14 years, company says, yeah, we're just going to give you $7,000, even though we really shouldn't have to. Well, you see in the bottom there that he's owed 12 to 15 months of severance. Now, if this person is, making $47,000 a year, that's a difference of probably over $40,000 to $50,000 difference. That's why we use the severance calculator, John. That's why you have to use it as well. Go to pocketemploymentlawyer.ca.
7,047. Yeah, a little off.
Slightly, if you're going to
probably improve it a bit.
Picky that way, but yes.
Exactly. Phone call number 2 again from our live radio shows across the country is coming up right now.
Question. So I'm leaving for maternity leave soon, and I was just filling out the forms the other day for my employer, and I read on it that it said that if I'm let go during maternity leave, I would not be owed severance. Is that proper, or am I missing something there?
No, they're missing something there.
Yeah, and you often ask me when I talk about parental leave and maternity leave, do we really need to talk about that in this day and age and the 21st century? Is this still an issue? Well, this call tells you how big an issue it is. Nonsense. Of course it's nonsense. Your employer can't fire you. Number one, they can't fire you when you're on parental leave, full stop. But if they did to avoid paying you severance, that's just absurd. Of course you're owed severance, but remember, if an employer just lets you go while you're on leave, in most cases, illegal, employment standards violation, human rights violation, can't do that. So this employer, I don't know exactly what they're thinking and where they got their legal advice. Nonsense, illegal, and if anything happens to you at all while you're on parental leave, you call me.
Just ahead, our main topic, fact or fiction, termination for cause. That is on the way, plus our third phone call of the show. All that coming up after this break. To reach out, Lior, anytime, 1-855-821-5900 and help@employmentlawyer.ca. We're coming right back with more of the Employment Law Show.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back, Employment Law Show. We're standing up now. It's nice. We need to get a little exercise. Phone calls is what we do this entire show. We do 3 of them each week, and we get a ton more on our weekly radio show. Reach out, make that phone call. It'll appear on this show, possibly. EmploymentLawyer.ca is how you find a radio station near you. Lior, let's get to phone call number 3 as promised.
I'm working for the company, and for the last 8.5 years, the company was doing a gas allowance for me every month, and I would just hand in my receipts and get paid, basically get compensated for those. A couple of months ago, they just basically took that away.
How much in a month usually would you submit for gas?
About $400 to $500 a month.
Ooh, that's a big hit.
That's a huge hit. And usually whenever we're talking about a significant change to compensation, that may not be legal. Now, if your employer now essentially is reducing your pay by $400 or $500 a month, that's exactly what this is. If you used to get paid for this, now you're not getting paid, it's the same as a pay cut. Car allowance, gas allowance. Now, generally speaking, an employer can get away, and I say this in quotations because they shouldn't, but they could potentially get away with the change to your compensation if it's 10% or so or less of your compensation. But once we're beyond 10%, it could be a constructive dismissal. So what a constructive dismissal is a situation where the terms of your employment are changed in a negative way, and you decide to consider that as a termination of your employment. So yes, getting rid of gas allowance, car allowance, if it becomes a substantial financial hit, can absolutely be a constructive dismissal, and employers should not do that. Now, if you're faced with that situation, sometimes the way to actually fix it is not even to go the constructive dismissal route at all. You get me involved, I send them a letter, and they back off. Okay, and that works very well as well. So if you're faced with that situation, a change in pay, whichever way you get to that change in pay, call me and let's discuss it.
So that could be part of your compensation if you're let go as a severance package. For instance, that $400 or $500 a month for 18 months could be rolled into that, right?
Absolutely.
Substantial.
So when it comes to your severance, all components of your compensation have to be addressed. So if it's a car allowance or any other allowance that you get as a matter of course, yes, that has to be paid as part of your severance. So it's not just your salary. So yeah, car allowance, but also bonus and benefits and commissions and pension contributions, even a gym allowance that some employers provide. All that would have to be included.
Time for the weekly topic, that is fact or fiction, termination for cause. Lior's going to answer all of these quickly and thoroughly for sure. Number 1, Lior, termination for cause is considered the capital punishment of employment law. You love that term.
I do, and I didn't use this. It's not me that created that term with the context of termination for cause. It's been used by our courts. But here's why that's so appropriate, because capital punishment, we think about that as the worst penalty for the worst offenders. It's exactly what a termination for cause is. It's the worst penalty because if you think about it, there's nothing worse that your employer can do to you, right, other than terminate you for cause, meaning you can only be receiving that penalty if you did something terrible, if it's something so bad that allows the company to just avoid paying you severance. In most cases, when you're terminated for cause, that is in fact a wrongful dismissal. You're not deserving of that capital punishment. So anytime you're let go supposedly for cause, you have to absolutely give me a call.
All right, fact or fiction number 2, Lior. Termination for cause can occur because of errors and poor performance.
Well, generally, I'm going to say that's fiction, and that goes back to the fact that it's so difficult to terminate for cause. It's not enough that you made a mistake. It's not enough that your performance was not adequate. That in itself is just not going to be enough to let you go for cause, even if you made a mistake. Now, the only way that could potentially become a termination for cause is if you were warned, you were given opportunities to improve, you were given help and training, and you still can't do it. Maybe after a while, at some point, the company says, okay, enough is enough, we've done everything we can. But to just get from 0 to a termination for cause just because you made a mistake, not going to be legal. So that, again, would be fiction.
So they have to build up a case. I guess, 3-strike rule is a bit of an oversimplification, but something along that line. Right?
It's an oversimplification, but it's also not a bad rule. Generally speaking, for a company to terminate someone for cause for performance reasons, for errors and mistakes, I would want to see probably 3 instances of trying to improve the behavior, trying to discipline, and if they fail, maybe then can the company terminate for cause. Too often, John, what I see is an employer saying, well, you made that mistake, here it is, you're gone, you're out, no severance for you. Well, that's a wrongful dismissal.
We're doing termination for cause, fact or fiction this week. Number 3 is this: it is typically very easy for employers to prove termination for cause.
Well, that flows exactly from what I said before. Of course, that statement is false. It's fiction. It is, in fact, very difficult. It's extremely difficult to terminate for cause and to prove cause. And remember, the obligation is on the employer to prove it. You, the employee, don't have to disprove it. You don't have to prove that the employer is wrong. They have to prove that it's right. So number 1, they have to show what you actually did. It's not enough to say, we think you did something bad. They have to prove it. Number 2 is once they prove it, they have to then show that they disciplined you before, that they gave you those opportunities, that it wasn't an isolated incident. One incident is almost never going to be a justification for cause. So remember, the bar is very high. It's very difficult to terminate employment for cause.
A couple more of these, Lior. Number 4, employees do not receive severance pay if correctly terminated for cause.
That is correct. That is fact. If the employer did whatever it was supposed to do, it dotted its I's and it crossed its T's and it gave warnings and it was able to prove everything, and whatever the employee did was very bad, in those limited set of circumstances, which frankly are fairly rare, yes, the employer can let the person go without any severance. But most cases, that's not what happens. Probably out of 10 terminations supposedly for cause that I see, 9 of them are not even close. So if you're let go for cause, unless you did something like you stole, you committed fraud, you hit somebody, unless you did those things, it's probably not cause.
All right, termination for cause, fact or fiction, last one for this week, Lior. Many employees fired for cause have been wrongfully dismissed.
And it's difficult sometimes to understand that just because, or even though you did something wrong and you were let go, you were still wrongfully dismissed. Doing something wrong doesn't mean you don't get severance. You're still owed severance. It's still a without cause termination. So most people that supposedly were let go for cause have been wrongfully dismissed and can be owed as much as 2 years severance.
We are going to terminationquestions.com after the break, so stick around for that and lots more on the way. In the meantime, that number, anytime, 1-855-821-5900. Email is help@employmentlawyer.ca. This is the Employment Law Show. Stick around. We're coming back.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Employment Law Show. Good to have you sticking around with us. I'm John Scholes. He is Lior Samfiru. Of course, you want to reach out to Lior anytime you can. 1-855-821-5900. That would be the phone number. If your email address is simpler, you can use that, help@employmentlawyer.ca. And the website built just to make you smarter. It's free. It's anonymous. Access to that severance calculator, which is key. pocketemploymentlawyer.ca. I'm going to give you another one, terminationquestions.com. That's an easy one to use. Again, it's anonymous. Throw your questions in there. Lior's team answers them, and you'll have that full answer. And you can take it from there. Here's the one for this week, Lior, anyway. It says, I was forced to quit my job due to ongoing harassment from a manager. After speaking to HR, I was told my concerns were unfounded and that I should look for, quote, other opportunities. I lost a bonus as well as my extensive benefits. Do I have any recourse?
Yeah, this is really a problem for an employer to behave this way and to put an employee in this situation. And unfortunately, I get exactly this question or variations of it every single week, sometimes almost daily. So let's talk about this for a second. Your employer has the legal obligation to protect you from harassment, from bullying, from any poisoned work environment. That's a very important and basic obligation that every employer has. That also means that if you are being mistreated in the workplace, doesn't matter by who, you should always feel comfortable and confident to tell your employer about it, whether it's HR, whether it's the owner, whoever the right person in your organization is. And when I say feel confident, you have to understand that you cannot be let go because of it. You cannot be punished. Your employer at that point has to investigate it, take it very seriously. And ultimately, if it's determined that you were mistreated, they have to fix the problem. Maybe they have to fire the person that's mistreating you. Maybe they relocate them. Maybe they provide them with better training. But they have to deal with it. Now, in this particular situation, this person says, well, I tried to do that. The company kind of brushed me off and said, yeah, maybe you should just now go. Well, no, it doesn't work that way. So this is really taking someone that's been being mistreated and telling them you don't have a place here anymore. It's the equivalent of firing them for all intents and purposes. Can't do that. So if this person leaves because of this, if she says, well, you know what, my employer dropped the ball. They didn't protect me. And in fact, they just want me gone because I raised harassment issues. That now becomes a termination, constructive dismissal. She's not being fired necessarily, but she's leaving because of how she's being mistreated or because her employer is not going to protect her. It's a constructive dismissal. She's owed severance. That means she's owed her bonus. She's owed her benefits. She's owed her salary, all of it for the duration of the severance period. So remember, if your boss is not dealing with this properly or HR department is not dealing with your harassment complaint properly, you have recourse. Always give me a call.
You know, it's not laid out in this email or termination question, Lior, but I can only assume that this poor person didn't have anything to back up their say, like they didn't produce emails, correspondence saying you did this, you've done this, just for the record, you harassed me on such and such a day. Can that bolster their case?
It's always ideal if you can prove it, if you have objective evidence, you have an email, you have a recording, I love recordings, that proves that harassment. But in some cases you may not. The company still has to investigate. They still have to take it seriously. They still have to interview other people and get all the perspectives and find out the right information there. The company can't say, hey, you didn't show us a recording or an email, so we're not going to believe you. It doesn't work that way. The company has to investigate. And a lot of employers don't want to do that maybe. They say, you know what, we'll let the kids handle it. Doesn't work that way. Illegal, you have to investigate. And it's not just the right thing to do, it's the legal requirement.
You know, you said recording there. I know a lot of our viewers that's going to prick up their ears going, recording. How does that even, that sounds sneaky. Is that legal? How do I go about doing that? What is the parameters for that?
Love recording because you can't deny if something is recorded. So remember, you are actually allowed to record a conversation that you're part of. Now, you can't record a conversation that you're not part of. So I can't leave a recorder in the boardroom and record other people talking. Maybe I want to know what they're saying about me. But that's still illegal. That's potentially a criminal offense to record other people when they don't know they're being recorded. But if I'm speaking to someone and I have a recorder kind of in my jacket pocket that person doesn't know about, I can do that. And I can use that, and that's absolutely fine. So in some situations, I'm going to tell you, yeah, if you know your boss is saying bad things to you, mistreating you, bullying you, yelling at you, record them, okay? Next time you speak to them, have the recording device or maybe just your phone, And if you can have that recording and it shows what you're saying that it's going to show, that could be all you need to prove a constructive dismissal.
Want to mention as well, another way to reach out to Lior anytime in their live stream. They do that on Facebook and YouTube. To take part, go to @STLawyers. For this week, Lior goes like this. After being diagnosed with arthritis, I spoke to my boss about possible accommodation. He refused these requests. I've since received negative criticisms regarding my performance. I'm worried I will lose my job. What can I do?
So the one thing I want to say about accommodation is it's not enough for you to go to your employer and say, I need accommodation, okay? In many cases, the employer is going to say, that's fine, we believe you, we trust you. If you say you need accommodation, then we'll accommodate. But to force the company, to make the company be legally obligated to accommodate you, it needs to come from a doctor. So if you have your doctor that you see, whether it's a family doctor, a specialist, maybe even it's at a walk-in clinic, if you have a doctor saying you need a certain accommodation, work from home or modified hours, modified duties, give your employer that doctor's note. All right? If you do, they have to make it happen if it's at all possible. They can't say no. They can't say we don't want to. They can't say we don't believe your doctor. They have to accommodate you. If they refuse still, it's human rights violation. It's a constructive dismissal. See how fast the law is going to provide you with remedies in that situation. But what you don't want to ever be in a situation is that you're trying to continue working when you know you shouldn't, or you're not being accommodated because you didn't get that doctor's note. Take the time to get that doctor's note. If anything happens that's not in line with what the doctor says, you just call me.
You know, the negative performance reviews seem to begin after the request was denied. That seems painfully obvious that they're working up to a termination.
So the employer becomes aware that the person has a medical condition, they need accommodation. All of a sudden, they become a bad employee and they start getting negative performance reviews. Well, it becomes clear that at that point, what the company is doing is they're picking on the person because they're sick. They're trying to get rid of them. That's a human rights violation. You cannot be mistreated, bullied, lied to, bad performance reviews just because you're sick, just because you have a medical condition or because you need accommodation. And if your employer does that to you, no. Illegal, and you really should not let them get away with it.
Okay, we're going to slide over to our last feature for the show again this week. That is Employment Rights Rapid Fire. Okay, Lior, question number one for the rapid fire this week. Can employees take sick leave?
You can take sick leave. You can take sick leave for as long as you need to. You have to have that doctor's note. Kind of a recurring theme of what we talk about. That doctor's note is very powerful. Your employer is not up to them to decide. They don't need to approve the sick leave. Once your doctor says you're sick, you cannot work, you can take that leave.
Rapid fire question number two for this week. If an employer's long-term disability benefits are cut off by the insurance company, does that give their employer the right to fire them?
Absolutely not. You cannot be fired because you're sick, and you cannot be fired because you've been denied disability benefits. That could also be a human rights violation. Those are separate things. Your employer should always follow your doctor.
Number three, do employers have an automatic right to implement temporary layoffs?
Absolutely not. There's no automatic right for temporary layoffs. In most cases, if you've been put on a temporary layoff, that is a constructive dismissal. You can treat that as a termination and get your full severance.
All right, he's 3 for 3 so far in this rapid fire. Number four right here. Are you entitled to any outstanding overtime pay when you lose your job, Lior?
Absolutely. Not only are you entitled to outstanding and accrued overtime pay, if you earn overtime pay regularly, that has to be included as part of your severance. So if you earn $300 a month in overtime, that has to be included as part of your severance as well.
Number five, can an employer refuse to pay severance?
No, that's the thing. It's not up to the employer. Not only do they not get to decide if they should pay severance, they don't get to decide how much severance. The law takes care of that, and your severance entitlements are far greater than you realize.
Okay, one last one as we go here, the rapid fire section of the show. Can you be forced to resign or retire?
No, by definition, a resignation is something that you do unilaterally. You can never be forced to resign.
All right, and he works without a net. Incredible. Done for another week. You want to reach out now that we're done and contribute to the show anytime. Make the phone call, 1-855-821-5900. Help at employmentlawyer.ca or pocketemploymentlawyer.ca. Great website. Visit that one as well. We'll catch you next time right here on the Employment Law Show.